Hey everybody, it's Mike Kennedy, Vermont Bar Council, here to walk through the proposed changes, amendments to the Vermont Rules of Professional Conduct that the Supreme Court put out for comment earlier this week. I'm on my deck. It's an absolutely beautiful night. And yeah, so I'm spending it sitting on my deck talking about legal ethics and the rules of professional conduct. Third-year law student Mike Kennedy would have no idea why we're doing that on such a beautiful night. But here we are. And I'll tell you, third-year law student Mike Kennedy, it's better than what we did last night on this deck on a beautiful night, which was watch the Celtics blow a 14-point fourth quarter lead in an important home playoff game. Okay, so earlier this week, the court published for comment proposed amendments to the Vermont Rules of Professional Conduct. I'm going to walk through them now. That I've included the link in the blog post, link to both the text of the proposals themselves as well as a summary. Some people consume content, learn differently. So I'm doing this by video and obviously the audio too. So first, Rule 1.2C. This is the rule that authorizes lawyers and clients to agree to limit the scope of the representation as proposed. The new language would require those agreements to be confirmed in writing. And also the new language would require a lawyer who is providing assistance in the background that has not entered a limited appearance with the court to advise the client to comply with any rules of the tribunal regarding participation by a lawyer in support of someone who otherwise appears to be pro se. So for instance, the Second Circuit has a local rule that requires people to disclose whether or not they have received legal assistance in connection with a paper filed with the court. That's what this proposal gets at. We've also proposed, in addition, excuse me, sorry about that. There's an ambulance now next door. I have no idea what's going on, so I'm going to pause for 1 second. Oh no, it stopped backing up. Okay. New comment 5. So Rule 1.2A makes it clear that the client owns the objectives and the lawyer decides the means by which those objectives will be pursued. This comment makes it clear that in pursuing those objectives, it's not an ethical violation to, for instance, agree to reasonable requests from opposing counsel that don't prejudice the right of the lawyer's client. For instance, a reasonable request for an extension of time. It also sort of gets a little bit more at the civility issue, makes clear that a lawyer doesn't violate the rules by choosing to act civilly while representing the client and to treat people with respect. Moving on, Rule 1.2, new comment 15, it's old comment 14. This refers back to paragraph D of Rule 1.2. That is the paragraph that makes it a violation for a lawyer to advise or assist a client to commit a crime, to engage in conduct that's illegal. You'll recall that 5 or 6 years ago, we adopted a comment to that rule to make it clear that a lawyer doesn't violate the rule by assisting a client on matters that are legal under Vermont's cannabis regulatory scheme. Those cannabis related laws have changed. They're now in a different spot than they used to be. All this does is reflect the fact that they're now in Title 7 and no longer in Title 18. That's the extent of the changes to Rule 1.2. This one's two here that are pretty important. This is Rule 1.6, the rule that sets out the duty of confidentiality. First, we are proposing that Rule 1.6 paragraph C sets out the situations in which a lawyer is permitted but not required to disclose otherwise confidential information, even without the client's consent. Adding language in C3 to make it clear that it's not a violation of Rule 1.6 to disclose information to me, bar counsel, when making an ethics inquiry. We've operated that way for many years now. We're going to officially put it into the rule. Later, new paragraph C5. This one is designed to help lawyers when they're moving from one firm to another. And, some of you have called me recently to talk about, well, Mike, either we're considering hiring somebody or I'm considering going over there. We want to do conflict checks before we make an offer and accept an offer to make sure that, can't bring somebody on and then find ourselves knocked out of many cases. So new paragraph C5, if adopted, would allow lawyers to make limited disclosures to perform those conflict checks when considering a potential change of employment. This tracks the ABA model rule. Also proposing to add paragraph D, which sort of captures tech competence to the extent it applies to confidentiality, meaning that lawyers shall make reasonable, or the new rule would state that lawyers shall make reasonable efforts to prevent the inadvertent disclosure of or unauthorized access to information relating to the client. The comment explains that a little bit more, but this gets at, you got to understand what it means to keep confidential information that you're storing electronically and to take reasonable steps to try to protect that confidentiality. Remember, a breach is not necessarily a violation as long as you took reasonable safeguards to prevent breaches from happening. Okay, the comments track the proposed changes and are self-explanatory. Next, we get to some proposed changes to the trust accounting rules. So this is to firm up, shore up protections for clients for whom lawyers are holding money. 3 proposed changes. The first would make it so that only a lawyer admitted to practice law in Vermont or a person under the direct supervision of a lawyer admitted to practice in Vermont shall be an authorized signatory on a trust account or shall be authorized to make transfers. Records of deposit must be sufficiently detailed to identify what was deposited. The comment explains that a little bit more. And withdrawals shall only be made by authorized electronic transfer or by check payable to a named payee. So no ATM cards, no checks made payable to cash. A couple more proposed changes in what would be new relabeled paragraph C, clarify that all the different types of accounts that are subject to the Supreme Court's authority to conduct compliance reviews and audits. Not substantive changes though. Rule 3.1, rule on meritorious claims and contentions. This change won't affect many. What this rule does is it's codifies Rule 11. You can't bring frivolous claims. It's always include language that says it's not frivolous or a violation of the rule for a lawyer in a criminal defense case to hold the state essentially to its proof. You can conduct a defense, present a defense without violating Rule 3.1. We've added language, again, tracking the ABA model rule that provides the same exception for lawyers who are representing people in hospitalization cases. Rule 4.4, this is paragraph B. This is the rule that applies when a lawyer receives something that the lawyer knows or should know was inadvertently produced. The current rule refers only to documents. I think that's a little outdated. We don't want to get into situations where we're litigating whether electronically stored information constitutes a document or not for the purposes of this rule. So the new language would require a lawyer who receives information relating to the representation of a client that the lawyer knows was inadvertently sent shall notify the sender. A new comment, paragraph, comment 4. Just remember that we've talked about this. I've talked about this at a couple seminars. The duty under 4.4b to notify the sender when you receive something that you know or should know was inadvertently sent. There are other duties that apply as well. For instance, Rule 26 of the Rules of Civil Procedure gets at the duties that apply when there's a dispute as to whether that inadvertent production constituted a waiver of the privilege. This just reminds lawyers that all we're talking about here is the duty to notify the sender, the ethical duty. We have some proposed new comments to Rule 5.3. These comments get at the fact that more and more now lawyers are hiring people who work to do certain tasks related to litigation or representation for them. And it gets at the duty to make sure that those people, for instance, contractors, investigators, what they do could come back to you, the lawyer. Make sure that so you basically have to make sure they understand that they can't do what would be a violation if you did it. It's part of the rule that already applies to the people who you supervise. Proposed change to Rule 5.5. This is the rule that prohibits the unauthorized practice of law. The proposal here would be new comment 22, and this tracks several advisory opinions that have issued since the pandemic started. One by the ABA, 7 or 8 by other states. They're referenced in the board note. And what it gets at is this: the lawyer who is not admitted here in Vermont, but may, for instance, have a condominium here, second home here, comes here, doesn't get admitted here, continues to work on all the same things the lawyer was working on at their office and wherever else, say New York City, does exactly what that lawyer would do if in the office in New York City, but comes to Vermont. This comment would make clear that that's not the unauthorized practice of law for the lawyer to do what they're doing in their home jurisdiction from Vermont, as long as they comply with certain restrictions. For instance, you can't hang out a shingle, can't, have people come in from Vermont, give them advice on Vermont law. You can essentially do your job as you were doing when you lived at the other place. Started to ramble there, sorry. The board note goes into the different ABA opinion, different advisory ethics opinions, and links to them if you're interested in reading more. Rule 8.3 is the duty to report. My good friend Joan Wing, may she rest in peace, used to call it the rat rule. New language in comment 4 makes it clear that when you call me with an ethics inquiry, I won't say, yes, you have a duty to report that person. No, you don't. That's not my role to comment on whether another person, other than the person who's contacted me, has or has not violated the rules. My role is to tell you what your duty is. I mean, what the rule is. And the rule is, if it's in Rule 8.3a, if you know that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness, you have a duty to report it to the appropriate authority. Some people, not many, but some, call me, know it's completely confidential, know that I can't share anything that's reported to me with disciplinary counsel or anybody else, and just say, hey, Mike, I'm not doing anything here other than to let you know that so-and-so did this. That doesn't satisfy the duty. You can call me to seek guidance about the scope of the duty and what other jurisdictions have held falls within the duty, but just like, hey, Mike, want to give you a heads up, now I'm out. That doesn't satisfy the duty if one exists. And then finally, some proposed changes to Rule 8.4b. Rule 8.4b makes it misconduct to engage in conduct that involves a serious crime. It's defined. We're changing the definition. They're proposing to change the definition. And the reason is this, that in administrative order, in the Supreme Court Administrative Order 9, that's the order that sets out the disciplinary process. That includes a provision that allows disciplinary counsel to seek the immediate interim suspension of a lawyer pending the completion of an investigation. It's for very serious cases when a lawyer has violated the rules and presently poses a substantial risk of harm to the client's public, the analogy is it's like a hold without bail in a criminal case. So it's very rarely invoked. Most of the time, if you're under investigation, you keep right on practicing. The disciplinary, in Administrative Order 9, it authorizes disciplinary counsel to seek that interim suspension in certain cases involving crimes committed by a lawyer. The definition of a serious crime in Administrative Order 9 is different than the definition of a serious crime in the rules of professional conduct, so that right now it's possible for somebody to be suspended on an interim basis for having committed a serious crime as defined by Administrative Order 9, but then not ultimately be sanctioned for violating the rule that prohibits serious crimes, because they have different definitions right now. So we're seeking to harmonize those, make them the same. That's it. Those are the proposed changes. Comment period closes on July 11th. Don't forget to check out, and this is in the blog, there's also pending a proposal to amend the attorney licensing rules so as to require lawyers to disclose on the attorney licensing statement whether they carry malpractice insurance, professional liability insurance. That is in a different proposal that went out a couple weeks ago. The comment period for that closes June 20th. That proposal would exempt from having to disclose whether they're covered lawyers who work for the government and lawyers who are in-house counsel. The proposal has its genesis in a matter that was referred to a diversion panel of the Professional Responsibility Program, where in the context of reviewing that diversion case, one of the panel members asked the lawyer who was appearing before the panel something to the effect, "I assume you've notified your carrier." The lawyer responded, "I don't even have malpractice insurance." The person assumed that was a violation, only to be informed, no, nothing in Vermont requires lawyers to carry malpractice insurance. That led to the creation of a joint committee of both the Professional Responsibility Board and people appointed by the Vermont Bar Association's Board of Managers that looked into whether to, how to approach the malpractice issue. And the joint committee looked at 4 things. 1, do nothing, maintain the status quo. 2, recommend that the court require lawyers to purchase malpractice insurance. Only 2 states do that right now. 3, recommend that the court amend the rules of professional conduct, specifically the rule that sets out the duty to communicate certain things to clients. Amend that rule, as New Hampshire has done, to require lawyers at the outset of the representation to disclose to a client whether, if they don't have malpractice coverage, or if their malpractice coverage is below certain amounts. And 4th option was, which several, I think, I can't remember exactly how many states, several, handful, require lawyers to disclose on the licensing statement whether or not they're covered, and make that disclosure available to the public. The committee ultimately came down on the final one, made that recommendation to the both the PRB approved, as did the VBA Board of Managers, made the recommendation to the court, and the court has put that out for comment. That comment period closes on June 20th. Comments for that, the malpractice rule, as well as the changes to the rules of professional conduct that I just walked through, should be emailed to me, michael.kennedy@vermont.gov. That's it. Give me a call if you have any questions. And if you have any comments, send them in, and I'll keep you updated on what goes on. Thanks very much. Have a great night.